Welcome to Your Lettings Journey, a brand new podcast that's essential listening for landlords with property in North London. Now, everyone will have their own unique landlord journey, from the way they get into property to the way they hang up or pass on their keys, and then all the different decisions in between. But along the way, we're all faced by many of the same issues and potential pitfalls. I'm Rachel.
And I'm Ramesh, and together we have a lifetime of experience as landlords, letting agents and tenants that we want to share with you to help you navigate your lettings journey.
So if you're an experienced landlord wanting to make sure that you're keeping on the right side of all the rules and regulations, or if you're completely new to this game and don't know where to start, then this is the podcast for you.
Your Lettings Journey is produced by Belvoir Enfield and Central Housing Group. For more information, visit belvoir.co.uk/Enfield and centralhousinggroup.com.
This week, we touch on the Renters Reform Act for the first time. Now, this is still a long way off being implemented. So how can it be adding to the delays and backlogs in the courts and with the bailiffs? This week, I'm joined by eviction specialist Rossanna Yarleque, who's going to answer exactly that question. She's also going to explain to us why, if you're employing someone to get your property back, you need to be completely open and honest with them, even if you've made mistakes as a landlord. Good morning. I am joined today by Rossanna Yarleque from Fahri LLP law firm in Whetstone. Hello, Rossanna.
Morning.
Good morning. Thank you very much for joining us.
No problem.
So Rossanna is a litigator, senior litigation, if I believe. Is that correct?
Yeah. Long in the tooth now.
Long in the...
I know I don't
glowing
look
this
it,
morning.
but...
I know, absolutely glowing this morning. It's the way the hair is working with the headphones.
Yeah. Took me a very long time to get this to work.
But today, although we're being slightly lighthearted, we are talking about the less pleasant side of landlord and tenant, which is evictions and the current market and the court system and everything else and how things are at the moment, because obviously things are quite testing when it comes to rental at the moment. But before we start that, tell us a little bit about yourself then, Rossanna. How did you get to be at Fahri law firm and what led to that?
Funnily enough, an old client who happens to also be a client of Fahri, found out that I was leaving my previous firm, got quite upset because I actually thought, oh, maybe I don't want to do evictions anymore. Maybe I want to do something else. And he said to me, I don't know if Fahri are looking to hire anybody, but if you are thinking about carrying on with evictions, please do, because you're the only person I want to use. I think you should give them a call. So I did, sent them my CV, had a meeting with them, and here I am.
So this is a client who does a lot of evictions then,
Yes.
is it?
Yeah.
Oh, big landlord, big portfolio.
Big portfolio, yeah.
Okay. So what led you to get into evictions in the first place? Did you go to sort of law school and think, oh yes, I must do evictions? Was that?
No, funnily enough. So I did my degree. Whilst I was studying, I was working for a will writing company. And I was, when you walk through a shopping centre and you have those, and I'm sorry if anybody doesn't do that, they do this for a job, but the annoying people that approach you and go, hi, have you thought about a Barclaycard? Have you thought about this and that, whatever. And so I was doing that for a will writing company. And as you can imagine, I was getting a lot of smart comments and this and that. But because I was studying it, I was able to explain how important it was to have a will and why everybody needed a will and everything like that. So I did really well there. So when I actually graduated from university, they offered me a full-time position. I was there for, I think I was their manager there for about 8 months roughly. And then my university girls decided they were going to go travelling. They asked me, want to come? And I did. And off I went. Got my little backpack, did Australia, Southeast Asia, all of that. Then came back and I didn't really know what field I wanted to work in. And I found a job with a gentleman who owned an estate agents as well, or a letting agency, I suppose. And he was dealing with evictions. So I said, look, I've got a law degree. I'm pretty sure I can do this. And on we went. And I was with that firm for, just over 10 years, I think, roughly.
Okay. So
Yeah.
you've got effectively 20 years of evictions.
Yeah, well,
roughly,
15.
Is it? 15 years of evictions behind you.
Yeah.
And have things changed a huge amount in that time, or is it?
Yeah, massively. Even the attitude of landlords, things are so close to the line now. With the laws changing, for example, in regards to their income, the tax, allowances, all of this has changed so much. I remember when I first started, I would get phone calls from landlords telling me, look, the tenant is in 7 months rent arrears. Now I need to do something. It's been a little bit too long. Now I'm getting phone calls. The tenant's 2 weeks late. What can I do? They're
that quick?
Yeah. And then to have to explain to the landlord, well, I'm sorry, in terms of evicting on the grounds of rent arrears, which is what's called a Section 8, there isn't anything you can do until they owe you more than 2 months, because at the 2 months point, that's when the mandatory ground comes in. Anything below that, it's only on discretionary grounds. So you're really at the mercy of the judge. So you want to make sure they owe you 2 months rent arrears at the time of serving notice and 2 months rent arrears at the time of the hearing for you to definitely get your order for possession.
Yeah,
because unfortunately, there are a lot, and I have nothing against tenants, but there are a lot of tenants that will play the system and simply just keep it just below. So if it's £1,000 a month, for example, they'll be in £1,800 of arrears. Not quite the 2 months. Yeah. Or they'll hit the 2 months and then boom, they'll make a payment and keep it just below. So that can be difficult for landlords to deal with as well.
That was going to be my question, was because you hear about, well, if it's paid off just before you go to court, then it's going to get struck out. So does that happen a lot? Basically, you're saying they play it, so
they can play. Yes, I have had. There's only been one occasion where a tenant has turned up and completely cleared the arrears. And if that happens, then you're not going to get possession because they've rectified the breach. But I have had other occasions where they've paid, 3/4 of what's owed, but they still owe X amount of pounds. And you're able then to rely on the other grounds. So when I serve a Section 8, I serve on grounds 8, 10 and 11. 8 being the mandatory ground, 2 months or more. And then 10 and 11 being persistently late with the rent and some rent lawfully due. So if for any reason we've lost ground 8, we'll go forward on 10 and 11 and explain to the judge, fair enough, they've just made a payment, but here's the rent statement. And you've got to submit, obviously, a fully explanatory witness statement and all of your exhibits, everything like that. And you're then going to show on the rent statement where you can see this is what they're doing. They're playing a game and it's really not fair. And then you are more likely to get an order for possession. But you just need to make sure that you cover your bases and not just serve on ground 8. That's something I have come across before, where landlords have simply served notice on ground 8 alone, which means that if they owe less than 2 months, you're out. Sorry.
Okay.
So I will always suggest, because the Section 8 notice is only 2 weeks long. So you're much better off having a look through and say, I can add more grounds. Add more grounds. You only lose 2 weeks. The last thing you want is to then go to court and for it to fail. So add as many grounds as you can. And that means it increases the likelihood of you actually getting possession.
Okay. And presumably, though, if there isn't that trend of being late, if they wait, if you get to court and it's actually no, because you would serve after 2 months, wouldn't you? And then you got okay. So there is still that possibility that on the first time you do it, there is no trend, but they pay it off before you go, and so you effectively have to do it again at some point because you won't get it on that first.
Yeah, potentially.
Okay.
I mean, what I tend to do with my landlords, I will ask them why do they want to evict the tenant? What is their main objective? Is it, I just want them to pay the rent, or I simply want the house back, whether they pay the rent or they don't pay the rent? And if that's the case, then I would normally suggest that we serve a Section 8 and a Section 21. So that even if they do clear the arrears, you can still rely on the 21 and get possession that way. And when you apply to court, you can apply to court on both of them. It doesn't actually increase your court fee. It's the one court fee, whether you're going forward on an 8, a 21, or an 8 and 21.
Okay. But you can you actually apply to the courts for both of those?
Yes.
At the same time? At the same time.
Yeah.
Okay.
Yeah. The only thing is you must make sure that the Section 21 has expired. So you can't Because the Section 21 notice is 2 months long and the Section 8 is 2 weeks. So long as the 21 has already expired, and obviously the Section 8 would have as well, then you can apply on both. That's what I normally suggest that my landlords do. You cover all your bases then.
And do you find that the majority of evictions that you're doing at the moment are actually the Section 8s? They are rent arrears, or are people now doing more Section 21s?
I'm finding that they're doing more Section 21s, mainly because they're of the belief that even if they were to get possession on the Section 8, they're likely not to get any of the money. And you have to bear in mind that obviously there are 2 ways of bringing the contract to an end. You've got the 21 and then you've got the 8. The 8 is a fault eviction. And because there's a fault eviction, it is a fault eviction, there will be a hearing. And at that hearing, the tenant will be allowed to put in a defence or a counterclaim or whatever it may be. So they can drag the whole process out for quite a long time if they want to, because you're blaming them for the end of the tenancy. So it's your fault. So they have a chance to defend themselves. What landlords tend to do now is just avoid all of that, because that's going to increase their costs if it ends up being defended. And simply saying, look, I just want the property back. Let's just use Section 21. Forget about the arrears. I don't think I'm going to get it. Or I'll do it on both. So that way I've got my bases covered. But generally, I'm finding a lot of landlords are actually starting to panic because of what has recently been in the press. And everyone's serving Section 21s because they're worried that they're not going to be able to serve Section 21s in I don't know, 2 months' time, 3 months' time.
Yeah, that's always been an interesting one. I know the change to Section 21s is... or removal of is something that a lot of people are panicking about. But in terms of serving Section 21 for arrears, I've spoken to a few people and they've said, yes, I've served Section 21 because the tenant's in arrears and it's easier than a Section 8. And then they have months and months and months of no rent coming in, which I have to admit, I did find slightly puzzling. I thought, why would you not just go down the Section 8 route and do the Section 21 at the same time?
So this is it. If the landlord doesn't want to wait for the Section 21, or it could be that they can't serve a Section 21. For example, it could be we're already in, we could be in month 2 of the tenancy and it's a 1-year contract.
Okay.
So there's nothing. Do you see what I mean? So you've got to judge each one as you get it. But generally, I would always suggest to my clients, serve both. You don't lose anything by having both running. If they pay, fantastic, they pay. If they don't, then when you go to court, at least you can get your order for possession and money judgment for the arrears. Okay. Now, whether or not you get any money out of that beautiful piece of paper is a whole different... we'll have another podcast on that. And we'll talk about debt recovery and enforcement.
Well, yes, because you do debt recovery.
I do that
you
as
do
well.
have the experience of debt recovery.
Yeah.
Okay. Yeah. With the Section 8s, and this is something that comes up quite often because you will have... so in all of our tenancies obviously have things like, well, sometimes they have, you can't have any pets, you can't smoke, you can't play the radio or, have like wild parties after it, a certain time of day. How often do people go to court on those grounds, and do they tend to be successful?
Not very often. And as far as how successful they will be, it would depend on how much evidence they have and how much of an issue what the breach itself. So I've had a few where landlords have contacted me and said, look, he's smoking, he's got a dog, that's not allowed. Let's be honest, they can go to the hearing and simply say, well, I've given up smoking. Yeah. Here's my Nicorette packet and I rehomed the dog. So I've rectified those breaches. Please, may I stay? And because those are discretionary grounds, you're at the mercy of the judge. So even things such as antisocial behaviour or nuisance, that is, so you'd serve a Section 8 notice on ground 12 for the breach of the contract. But you'd need to make sure, again, because it is a discretionary ground, that you have as much evidence as possible. So I had a recent case where there was antisocial behaviour and I had to produce witness statements, exhibit the photographs of the damage that's been happening and the issues with the neighbours and blah, blah. And we got it, no problem. It was fine. But you just need to make sure that you have as much as possible to, to fight your corner, essentially.
I think that is one of the concerns that people have with the removal of Section 20, future removal of Section 21, is that when it comes to things like antisocial behaviour, it is that much harder to prove. So a lot of people will just say, okay, well, I'm going to serve a Section 21 now, and that will be the end of that, rather than getting that evidence together to be able to present to a court. Because sometimes that evidence is quite difficult to get. If you've got people who are particularly unpleasant or intimidating, or just neighbours who don't want to get involved.
Yeah, of course. Well, they live there at the end of the day. And I'm sure that there's no reason. I mean, they could be feeling threatened for their own safety. So I understand that completely. So it is difficult for landlords.
Okay. So one of the things that we sort of touched on there, obviously, is the changes with the Renters Reform Act and the removal of Section 21. Is this something that you're concerned about? I know some people are jumping quite quickly, but is that a big trend, and how do you see this progressing?
So a lot of landlords are jumping quite quickly. You're right. I've had a huge influx in inquiries. I've had a huge influx in instructions. And I'm trying to explain to the landlords that this is just, at present, I think it's just at the second reading. So it's nowhere near royal assent yet. So you're probably looking at least another year before it gets anywhere. So there's no need to panic. If you've got good tenants, there's no reason why you should get rid of them. At the moment, it's, from what I'm hearing in the press, it's absolute hell out there for tenants themselves as well, just trying to find accommodation. So if you have someone who's paying the rent on time and isn't an issue for you, you're better off just keeping them for the moment anyway and wait and see what happens. Because once Section 21s, but once they get rid of the Section 21s, they are going to add other grounds to enable you to get possession. It's not simply going to be, you're stuck with them for life. You will be able to. So, for example, they're going to add another or additional part of ground 1 to Section 8. And ground 1 is that the landlord wants the property back because they want to move in. Yep. And what they're going to do is to allow you to also, or allow the landlord, I guess, to get the property back on the basis that their child wants to move in, or their grandchild wants to move in, or so that for their family use. Now, it's not going to go as far as niece and nephew and cousin and cousin's cousin's cousin, but it's going to be sort of your nuclear family. You'll be able to do that. Okay. So that does help if you're looking to sell the property, for example. They're going to add a ground where you can get possession of the property because you need to sell it. So it's not completely. You've got to go through absolutely everything with a fine-tooth comb. And I think at the moment, the way it's been set out, it's going to be a little bit open to abuse, but we'll see. Yeah, that's the only concern. But even, for example, with rent arrears, they're looking at changing that. So they're going to introduce a sort of 3 strikes and you're out, which is much more helpful to landlords. Because at the moment, as I said, you've got ones that are playing the system and just keeping it below the 2 months. Whereas this way, so long as they owe more than 2 months, at least 3 times in the last 3 years, they're out. Even if there are no arrears now.
Takes away the discretionary.
Yeah. So that makes it a little bit more difficult. I just think at the moment, everyone's panicking. Obviously, interest rates are rising like there's no tomorrow. And everyone is simply, a lot of landlords are really just jumping ship completely. Just, it's not worth it. I'm not making the money. I'm out, which is a shame because the industry is still very, very much alive. People need somewhere to live. Yeah. So, but what can you do? There's nothing you can do to ease their panic other than say to them, look, nothing is happening right now. You've just got to wait and see how it all pans out.
Okay, yeah. I think there's a lot of things added together that are sort of leading to landlords jumping ship.
Oh, yes.
And I think the Section 21 is it's like the final element.
The straw that broke the camel's back.
The straw that broke the camel's back. There's a lot of camels who are struggling at the moment.
Exactly.
There are a lot of straws. But you say it's not changing immediately. But I think even since before COVID, the timescales for getting your property back once you've been to court were actually quite long. I remember the first time I ever went to court for Section 21, and I think the time from the court hearing to getting a bailiff out was, they said to expect between 5 and 8 weeks, and that was because it was over Christmas.
Yeah.
But now the whole process is taking much longer. So I can imagine landlords thinking, well, it might be next year, but how long is it going to take me to evict them? And I want that to be done before this comes in. Yeah. What are the timescales for these things nowadays?
You're looking at anything from, depending on whether it's defended or not, or whether whether the tenant asks for more time, but you're looking at roughly 6 to 8 months now.
Okay.
It's potentially a little bit longer if they need to enforce using the bailiff. I don't know if you've seen any of the press recently in regards to bailiffs and personal protection equipment and everything that they've had. So there's been recent reports that the bailiffs, county court bailiffs in a lot of London county courts are unfortunately stopping doing evictions for the moment. And the reason they're doing that is a couple of months ago, a couple of bailiffs were stabbed, which is awful. And as a result, they've now knuckled down and made sure that they can only do evictions if the bailiffs have proper stab vests. And unfortunately, quite a lot of bailiffs didn't have those, which meant that everything was put on hold. Because let's be honest, no one expects to go to work and not come home. Fair enough. And I completely appreciate that. But as a result, everything has then been pushed back. You've had bailiff appointments that were booked, for example, for the beginning of July that have now been cancelled because they're waiting for the personal protection equipment. And then that's now going to be August or September. So the one that you had booked in August is now going to be November, December. And these ones may be ones where the tenant isn't paying the rent. So you're losing, I mean, especially in Enfield, for example, you're losing at least £1,500 a month, at least.
It's a bit worrying. I'm sitting here thinking, whenever I watch these things on TV, I'm thinking I'm fairly sure that those bailiffs have stab vests on underneath their jackets. It does surprise me a little bit that people going to bailiffs where you're going to have a fairly tense situation that they didn't have stab vests. Yeah. As sad as that may be, it does strike me a bit odd.
So the programs that you watch are High Court enforcement officers.
Yes.
So that's so you've got County Court bailiff and then you've got the High Court bailiff. You are able to make an application to the court on the base, and this is what we have done, on the basis of or for the reasoning really that the County Court bailiffs are struggling with keeping up with appointments. Okay. Please may I have permission to elevate it to the High Court for the purposes of enforcement. And you can get, at that point, once you've got permission, you can then get the High Court involved. Those bailiffs are the ones that you see on the TV, can't pay, we'll take it away, all of those programs. Yeah. Those are the ones that are fully kitted out. They've got the personal camera, everything sorted. And they can actually do the eviction. Once you've got permission, they can do the eviction within 2 weeks. The problem that you have is the time it takes to get that permission. That's the issue.
Because that's got to go back to the courts again to get that permission. And the courts have already got their backlogs. And
Exactly. So sometimes it will depend on each court. And normally I'll actually phone the court and find out what kind of a wait we're looking at for the bailiffs. But there have been times where I've told a client, look, there's no point. You're going to be spending extra money. You may gain a week or two. You may as well just wait for the County Court bailiff.
That long for the delays, really?
Yeah. But it depends on each court. Each court, I mean, some courts are busier than others. This was a South London court.
Okay. And the bailiffs that do the evictions, are they the same bailiffs that do normal debt recovery? Or are they separate? They're different. No.
So the bailiffs in the county court will essentially just do the evictions. That's it. That's all they're doing. Yeah. Just enforcing the order for possession. I mean, generally, the tenants have already left. I mean, a lot of tenants that have been evicted, excuse me, on Section 21, for example, may need to then be rehoused by the local authority. And this is another issue that landlords are having, is they can't understand why these tenants are not being rehoused once the notice is served. Why am I having to go all the way through the court process just for them to be rehoused later on? You're simply kicking the can down the road. Yeah. And unfortunately, there just isn't any housing. There's nowhere to put them. Yeah. So you're in this whole rock and hard place. What are you going to do? So you end up having to take it all the way. You've got your bailiff appointment, and only then, once the bailiff appointment is booked, will the council step in and rehouse, which is a shame, because the landlord then has to struggle and pay all of those costs as well. It's always one of those ones that puzzles. I had a case last year where we had to evict, and it was for non-payment. And fortunately, the landlord had a rent guarantee, so he was actually financially okay. Yeah.
But he was very confused as to why this person was having to wait until this point. Why were they were being advised to wait until the bailiffs actually arrived.
Mm-hmm.
And then I saw something earlier that was about the number of people in temporary accommodation and just in Enfield. Because apparently Enfield has the highest number of no-fault evictions in London.
Right. Okay.
For 2022, which I thought was just amazing.
Mm-hmm.
But they're also spending £850,000 a month on hotel accommodation and bed and breakfasts.
Yeah.
So that just says there is no accommodation that they have available to put people into. And 850,000 is a phenomenal amount of money to be paying on that. So you can imagine them saying, I'm going to make you go through the whole process to make sure you absolutely 100% want to evict this tenant, and there's no way back to save that tenancy. But yeah, for a landlord, it's not great. And in that instance, we waited 16 weeks for the bailiff appointment. From the point that they said, yes, we're going to give you a date, the date was 16 weeks later, which was quite a time. And then it was 10 months in total from going to court to having the bailiff.
Yeah.
It's a long time to wait.
It's a long time, exactly. And it's a long time if there are rent arrears. So imagine you don't have this rent protection insurance. This is the thing. I mean, I will always, I'm a huge advocate for that, because it's worth its weight in gold. Absolutely worth its weight in gold. And I would suggest any landlord that is looking to bring a new tenant in, get whatever insurance you can just to cover yourself, because you never know how busy the court system is going to be at that time. It may be fine, it may not. And if it's not, it's going to cost you a lot of money in lost rent if that's the reason that you're evicting.
So do you see the trends going up still now for people evicted because of Section 21? So is this going to get worse before we actually get to that point?
I think, yes, it's going to get busier, certainly. I think as I said, a lot of landlords are leaving the game. But I'm also very concerned as to how the courts are actually going to cope with the influx. That's my worry. So even if they're getting rid of Section 21s completely and looking at adding more grounds on Section 8, all of that would require a hearing. Whereas the Section 21 is what's called the accelerated route. And I say accelerated because it doesn't necessarily mean it's very fast. And there potentially isn't a hearing. It's meant to be just a paperwork exercise. So long as all your paperwork's in line, stamp, wonderful, here's your order for possession, great.
Yeah.
But if they're getting rid of that and they're now adding the grounds on Section 8, and Section 8s will always have a hearing, then you're looking at the matter getting administered by the court, being listed for a hearing on X date, then the hearing takes place, and then it just takes so much longer, really. That's my concern. So they are thinking about, or from what I've read anyway, they're thinking about adding a whole new, I suppose, housing court, let's say. But this is way in the future. And when will that happen? Are we going to be expected just to cope for the moment whilst that's happening? Or I don't know. That's what concerns me. I don't think it's been thought out very well. But
no, I think it all sounds very good. Certainly from the general direction of wanting to protect tenants and give more stable tenancies and all that sort of thing definitely sounds very good.
Yeah.
But in reality, how long does it take to set that sort of thing up? That's not going to be set up in a year's time, and to be able to cope, given that they can't cope at the moment. So I think that's one of the things that landlords are getting a little bit concerned about, is sort of you're making these plans, but you have no way of implementing this at the moment. Okay.
I mean, it might even be a completely different government. I mean,
it may well.
So who knows? And I think that's the issue. It's the uncertainty that's really concerning landlords more than anything.
Yeah.
But as I said, you've just got to, if that's what you want to do and you want to evict, fine, let's do it. And you just need to make sure that you're methodical with it all and chase it up when it needs to be chased up, and not just leave it and hope. Because unfortunately, I don't want to say he who screams loudest gets seen first, but technically, you need to keep on top of everything. Because if you're not on top of everything, then it will just fall to the bottom of a pile. So you need to make sure that you're proactive with that.
Okay. Now, for a while, there was a big focus, particularly during COVID and everything else, there was a big focus on mediation. Do you get involved in that? And do you think that is an option for a lot of people, or is that just nice words?
I don't get involved in that personally. I would say from all the cases, I've maybe had one that looked like potentially they could mediate, but generally, no, I don't see that growing at the moment. Not from my side of things, anyway.
I've always been very cynical about it as well. I think at the point that you come to say, I'm going to take you to court and spend, things have deteriorated at that point. So even if you do pay me the outstanding arrears, the relationship has broken down at that point.
This is exactly why I have that conversation with my clients to begin with. So what do you want to achieve? So if they pay the rent, are you happy for them to stay? Oh, no, I want them out anyway. Right. Let's serve a Section 8 and a Section 21 then.
Okay. So just to cut to the services that you provide. So you are an eviction specialist. And so how does your company operate? At what point would I, as a landlord, come to you and say, okay, I have a problem? And then how would you help me from that point on?
So I can take on cases, for example, if you've already served the notice yourself and you simply want to start the court process. So I have designed a questionnaire, and on the back of that is a checklist, which I simply email out to my clients. They send me over all the documentation. I'll go through it, and then I can start preparing the court papers to send off. It may be that they're right at the beginning, at which point I'll go through it, tell them what we need to do in order to make sure they can serve the notice. Because that's the other thing. There's no point in just serving a notice if you can't do anything with it. You need to make sure that everything's been done correctly before actually taking the jump and the leap to court, so to speak. But yeah, so I get involved from start to finish. It could be that a client already has an order for possession and they simply want help with appointing the bailiff. At which point, in fairness, I would probably just tell them the form they need to fill out. There's no point in you spending legal. I'm not trying to turn away business, but there's no point in you spending money using a lawyer to fill out a relatively simple form. I may as well just tell you it's form blah blah blah. Good luck. And I think a lot of recommendations certainly do appreciate that. I will tell them what they need to hear. They may not necessarily like it, but there's nothing I can do about that. But I'm much happier. They know, look, this is you've got to put all your cards on the table. I need to see what I'm working with. You can't simply, and you've got to tell me everything, warts and all. You can't simply hold back something. And then later on, we find out now there's a counterclaim for harassment and disrepair. And it just drives me mad. So that's the whole point of my questionnaire. So everything's at the beginning. I get to find out, about everything to do with the case to start with. And then I can advise the client on, right, this is going to be the best way to go forward. And it's going to cost X, Y, Z. But I do it all on fixed fees. So my fees start from as little as £250 plus VAT. And I, providing obviously the matter doesn't become defended, if I'm doing proceedings, it would be £650 plus VAT. If we're attending the court for you, we'll provide an advocate. And so none of that is time recorded. So my clients don't have the worry of picking up the phone and thinking, oh gosh, this is going to cost me. It doesn't work that way. I mean, providing, of course, you're not keeping me on the phone for hours on end, then it's fine. And I will generally keep clients updated on a weekly basis, even if there is nothing to update them with. I think that's something that is very comforting to my clients. And I know that they find very frustrating whenever they've come to me from another eviction specialist. They've not been happy with how they've been treated as client 14782 rather than Susan Smith, who is really struggling at the moment. Please, can you help? So I joke with my colleagues that we're not only lawyers, we're also counsellors and therapists, because they tend to offload on us. And with me, at least you're not on the clock. So,
but I mean, you're absolutely right. When people are going through a bad time with tenants, then it can be something that they just want to talk to someone about how unfair it is. And that can take an awfully long time. And, it's not personal. It's not you. It's, it's fine. How often do you find that there are some other circumstances, if something hasn't been done correctly, either the paperwork at the beginning or just the way the tenancy has been, the way they've managed a tenancy? So are there things like gas certificates that haven't been done and that sort of thing? How often does that become an issue?
Quite a lot. You'll be surprised. There are a lot of landlords out there that don't seem to realise how serious not being compliant actually is. And then the cold, hard truth comes out. Well, oh, you haven't done this, you haven't done that, you haven't, which again was the whole purpose of the questionnaire. I need to find out, when was this done? How did you do this? I mean, gas safety certificates, for example, that's one that is quite a sticky situation. If you haven't served a gas safety certificate at the start of the tenancy, or it didn't exist at the start of the tenancy, then Section 21 isn't available to you. That's the issue. So then you've got to look at other methods. Well, maybe I can go on the Section 8 route, and I'd have to go through the contract to find out whether there's anything else that we can rely on in order for you to get possession. Things such as the deposit. I mean, I had a client recently, and the deposit wasn't protected. So you then need to deal with that. And I remember them saying to me, "Oh, but they moved in 2003. They moved in 2013. The deposits weren't a thing then." Deposits have been a thing since 2007.
Yes.
But okay. But it is protected. It's in another bank account. So that's not protected. So you'd have to deal with that, obviously, in returning the deposit to the tenant. But they're still open to being sued. I mean, the tenant has 6 years in which to sue the landlord if they haven't protected the deposit and served the prescribed information within the 30 days of receiving it. So it's a difficult one.
So even if they do return the deposit and then go through the court process, they can still come back and say, actually...
If the tenant wanted to, yes. Yeah.
So you really are everybody's best friend at that point. It's been lovely talking to you.
Yeah. Auntie Rossanna. Yeah. No, I do have a lot of clients that will simply just phone and just want to vent, as I said. And that's fine. I mean, I know that being a landlord is quite stressful at the moment, but being a landlord stuck in the court system that really isn't moving very quickly is even more frustrating. So all I can do really is just be an ear for them and show them, look, this is the chase up that I did. Here's the email trail of everything that we've been doing. So they know that they're not simply just being ignored.
Okay. And you mentioned briefly earlier about the debt recovery side of things, because that's something that I know comes up. So if you don't have that rent guarantee in place and you have to, your tenant's not paying any rent and you're waiting 5, 6, 7 months, then you get your property back. The deposit only covers the damages, let's say, to the property. You're still in those arrears. How easy is that debt recovery for the average landlord?
How much information does the landlord have?
In terms of what the tenant does for a living and that sort of thing, or?
The more you know about your tenant, the easier it will be to then enforce that judgment. Because that's the problem. Let's say you evict on a Section 8, for example. You get your order for possession, fantastic. But then you also get your money judgment for the arrears. But it's only a piece of paper that says that Mr. Jones' tenant has to pay you X thousands of pounds by X date. And if they don't pay you, you've then got to look at enforcement options. So at that point, or really, when they become your tenant is the time that you want to do some proper referencing, try and get bank account information. If you've got that, you can apply to freeze their bank account. If you know where they're working, you can get what's called an attachment of earnings. So you can get money out of their payslip. If they own assets, for example, I have had cases where, although they're a tenant in London, they own property up north themselves. And if the debt is enough, you can then register a charge against the property that they own. So there's lots of things that you can do, but it will very much depend on what you know about the tenant. The more you know, the better. If there's a guarantor, happy days. You can go for the guarantor. If you have nothing about them at all, or for example, if you don't even know where they've gone, they've just up sticks and they've left and you need to trace them, I've got a gentleman that I can introduce you to that does tracing. He does it on a no trace, no fee basis. He's fantastic. He will find them, and then you can send the High Court bailiffs over to try and seize goods up to the value of what's outstanding. And that's the can't pay, we'll take it away, knock on the door, you owe X amount. The problem with that is it's residential, so they can't force entry. So there's never a guarantee that they're actually going to make a recovery. But having someone knock at your door and how many times do you actually slam the door in someone's face? It doesn't happen. It's like, oh gosh, hello. And the way they come dressed as well. It's,
you don't want the neighbours
seeing
them.
Make recoveries. Yeah.
Yeah. And they tend to be rather large people.
Generally, I found that, yes.
Oh, hello.
Yeah.
Do come in. Please
Yeah.
duck.
Yeah.
Sorry, I mean it's not funny because I know a lot of people. I think during the cost of living, they were saying that over 2 million people have had bailiffs turn up on their doors in England and Wales for one thing or another, not necessarily housing, and that must be pretty scary to have that happen. So I'm not trying to make light, but
No,
but yeah, if you're sitting there and you're 7 months, 7 months out of pocket, and you're possibly paying a mortgage as well for this property, then yes, you do want to have some way of getting that money back.
But I must add, though, and I'm sorry to interrupt, I must add that the landlords do have to make a commercial decision as well. Yeah. You don't want to throw good money after bad. And again, I'm not trying to turn away business, but if you can see, or once they've shown me all of the papers and I can see that this tenant, you're not going to get anything out of them, don't waste your money. I mean, happy to take your money, but I'm not going to give you the result that you want. So why don't you wait? This judgment will last for 6 years. In 2 years' time, their financial situation may be different. I had one case, which you'd be quite interested to know. This is many, many moons ago, but even before my Fahri days. And we managed to get a judgment against a tenant for £17,000 worth of rent arrears.
Wow.
And the client sent in the High Court bailiff officers, or High Court enforcement officers rather, and the gentleman had an old Volkswagen Golf worth 300 quid. Nothing. They couldn't make a recovery at all. So I reported this back to the client, and the client said to me, that judgment will last for 6 years. I will wait, and I will go after him in a few years. And she did. She contacted me 2.5 years later, I think, roughly. And we did a trace. We found out where this tenant had moved to now. And we sent the High Court officers out. And you would not believe, on his driveway was a Jaguar XR something. I don't know. It was worth 20-odd thousand pounds. Finance free. Clamped.
Of course.
On the back. Yeah, clamped on the back of the lorry. That was it. We were going to tow it away. He paid. And she actually ended up getting, I think, 20-odd grand with interest and legals and all of that. So she was, So there you go. So persistence does actually pay off as well.
That's amazing. And that's something I wasn't aware of, that you can hold on and then do it at a later date. I didn't realize that.
You don't have to do it immediately. It will last 6 years.
Okay.
So
if it is a Section 8 that goes to court with that, is there automatically a CCJ attached to that, or do they have to do so? So automatically Section 8. So that's the disadvantage of going down the Section 21 route, is that they don't have that CCJ, and you'd have to do something else to get
so that. Then what you would have to do is you'd have to then serve a letter before action and then take the claim into small claims court for the money. So you'd then you'd have two processes. Yeah. So you've done the eviction, and then you'd need to do the money side of things as well, separately, which just increases costs. So if you can, you could do it all in one.
Yeah, I think there's just some people that I've spoken to where they're sort of like, well, actually, no, I'd like the satisfaction of knowing that they've got a CCJ, even if there's absolutely no chance that money's going to come back. So if somebody is on particularly no income, has no assets, not working, what have you, then you think, well, there's no point in doing this because you're not going to get your money back. And yes, you might be told that you're going to be paid £10 a month or something, but you'll then be back in court again because you don't get that £10 a month.
Yeah. Yeah.
So, okay.
Well, a lot of landlords do it just out of principle, really.
Yes, no, exactly.
Yeah,
because it's not right.
No.
I'm loving the Jaguar on the back of the truck there. I think.
Oh, that's fantastic.
She was pleased there.
Oh, she was so happy. And I remember speaking to the enforcement agent at the time who was reporting it to me. He said, so it's at the back of the truck. I was like, oh, you're joking. And there's no finance on it. He's like, no, there's no finance. Like, oh, amazing. And he paid everything he owed. That was it.
Wow.
Job done. But those are few and far between. I mean, a lot of the time it's, unfortunately, you don't make a recovery, or you have to be very persistent. But as I said, the more information you know about the tenant, the better. If you have a guarantor, even better. If the guarantor is a homeowner, fantastic. So all of these things you need to get into place before the tenancy starts, which is why it's so important to... And I have nothing against landlords that self-manage. If you can do it properly, great. But if you can find an agent that can actually take care of that for you, if anything goes wrong, you're then in so much better position, you know?
No, I completely agree. The one thing that was coming through there was you have to reference, you have to do it properly.
100%.
And I'm always amazed. So, people keep coming up to or turning up to viewings and saying, "Oh, here is my reference." It's like, I'm not just accepting this random piece of paper from you.
Yeah.
We need to actually, we have somebody else that does the referencing, because I don't want to take the responsibility of getting that referencing wrong.
Yeah.
And then I was talking to a referencing company, and they were saying that the fraudulent applications are on the increase again because rents are so high.
Mm-hmm.
So for me, it's just another reason you've got to get it done properly. You get a guarantor if you need to get a guarantor, and you find out about these people, and you keep the bank statements on record so that you have those bank account details and things.
But that's the other thing. You could, I've told a few landlords, you've got a tenant that's paying the rent and they're no trouble to you, but you're worried, or you want to try and that you can get more money. You can get more money, certainly, and you can end up with a tenant who's promising you to pay double what the rent is at the moment. They may pay 1 month and then that's it.
Yeah.
So you've got to weigh that up as well. I'm not saying to landlords, don't evict tenants. Of course, if you need to evict them, you need to evict them. And I'm the person to use. Great. But at the same time, you've got to take a commercial view on things. And I think sometimes landlords, and I don't mean this disrespectfully, but they can sometimes be a little bit too emotional with it, and they need to be a little bit more commercially minded, I think, more than anything.
Yeah. No, I agree with you. I mean, it's a very good tip. Do you have any other tips for landlords who are, I don't know, either thinking that they might need to evict at some point because of the way things are going, or who find themselves in that situation where it's like, okay, I'm almost at the end of my tether and I need to evict? Are there any tips that you have for them to make the process smoother and easier?
So my one bit of advice really is to make sure that you, as a landlord, meet your obligations as a landlord as well. Just because the tenant isn't paying the rent doesn't mean you don't have a duty to not fix the boiler. Yeah. Things like that I find quite concerning. And I think landlords don't realise that their obligations are still there. They still have those repair obligations. So they need to make sure that they've done that. Otherwise, you run the risk of later on a counterclaim, or it just muddies the water. So stay professional with it. Make sure that you keep a nice log of what you're doing. If the tenant is not allowing access, keep a log of that as to why they're not allowing access, on what day did they not allow access, because that will make life so much easier in the long run. The last thing you want is to have to start an eviction and then later on things come out in the wash, and it just makes life so much more difficult.
Okay, so stay squeaky clean. Don't be emotional. It's not tit for tat. You have to do everything right if you want to win your case going forward.
Two wrongs don't make a right.
Two wrongs don't make a right.
That's
no.
it.
Okay, and as a last note, would you like to tell us about your chickens? Chicken maths. Tell me about chicken maths again. I like this one. Chicken maths.
My husband and I are avid chicken keepers. We have 11 chickens at the moment, and the way chicken maths works is, unfortunately, chickens only last for maybe 2 or 3 years. They don't last very long. And when one of them passes away and you want to introduce another, you can't simply introduce one chicken. You've got to introduce 2, because otherwise there could be a little bit of bullying. So you've heard of the pecking order?
Yes.
That's
is this
actually
where it comes from? Oh, wow.
Yes. So you will have head hen or chicken, who is the boss, and even she will go and eat. She's the first one for treats, and everybody else knows their position in the flock. So little one won't approach because they know that it's not their place. It's not their time. They've got to wait for head chicken to have her fill, and then they'll do it. So for that reason, there can be a little bit of bullying within a flock, which is why you never introduce just one lone chicken. It's got to be 2, or ideally 3. So then you end up with 4, 6, 9, and in my case 11.
And these are rescue chickens, are they?
Some of mine are rescue. Yeah, some of mine are rescue, and 3 are ones that we actually hatched ourselves. So I rehomed 3 what I thought were hens, and it turns out one of them wasn't a hen. He was a she. She was a he, rather. So we had to rehome him because where we live is as a residential area, so we can't have a cockerel. It's just not fair.
Okay.
And we let him have his wicked way, shall we say, for a little while, and then he was rehomed. Funny enough, to a family just outside of Enfield, and he sent me a photo his name was Teddy. So he sent me a photo of Teddy with his new women in this huge field, just living his best life. And I was like, oh, go Teddy. But anyway, so we had some eggs. We put them in the incubator, and then that's how we ended up with another 3, which thankfully are girls. So that's good. Yeah,
I love it. I'm just thinking, go Teddy. I think that's wonderful.
Oh, yeah.
Happy days,
living his best life.
living his best. That's wonderful. I think on that happy note, are you happy? Just before we go, are you happy for us to put your details in the notes and the comment section if people do need to contact you? Is that
yes,
okay?
Of course. Yes, no problem at all.
Okay.
I'm always happy to have a quick chat with landlords, even if they want to just bounce a few ideas around. Not a problem at all. I mean, as I said, so long as they're not keeping me on the phone for 3-4 hours at a time
for therapy.
That's fine. Yeah.
Okay.
Therapist is cheaper.
Yeah, probably. Yeah.
Yeah.
On that happy note, I have to say thank you very much. That has been very, very interesting. And I look forward to hopefully having you back again at some point when we know what's changing in future, or a bit more about the direction in future.
Yeah,
but
lovely.
thank you
Look
very
forward to
much.
it.
That has been lovely. You've been a lovely guest. Thank you.
Thank you.
And goodbye.
See you later.
Thanks.
Bye-bye.
Bye. If you enjoyed this episode, then we'd love your support. Please subscribe, leave a review, and share this episode of the podcast with your friends.
We'd also love to hear from you about any topics you'd particularly like us to discuss. Please send an email to yourlettingsjourney@gmail.com.
Thanks for listening, and see you for the next episode of Your Lettings Journey. Goodbye.
Goodbye.